It's good. You know what time it is. First off, I want to give a shout out to the two people that are locally disliking the video. I already have a sense for who it is because the way the analytics work and I'm able to move the thing. I need more haters. You guys are going to have to dislike about from here to the next 2 years to catch up the amount of dislikes with likes I have on the video. I appreciate it. You got to step your hate up. Jeez, aren't these guys just sad? But shout the commenter nation. You guys always looking out, holding me down. I really appreciate everything you guys said. And now I'm about to answer what TheCzarr Hodges said. And I'm going to do it in a specific manner so you understand that what phase they're in. And no, it's not confusing. After I explain it generally, I'll go through each manner and describe where it was at in the case, where the situations were addressed so far, and where it could be headed. It may pop up more information as I go through it that they're filling in the stages, but I kind of shortly wrote this down so that I'm able to give it to you. So let's go. You know, hit the donation, shout to commenter nation, donations in the description, rock with me. Here's how it runs down. There's 7 steps to exactly how any court case goes. And there is a differentiation in what happens at a certain point. And I'm going to tell you it's step 3 right now so you get it. And I'm going to tell you where they're at. So first there's bail. So first is bail. You get arrested. You have the chance to make bond, bail, whichever you want to say. The next one's arraignment, where you make an appearance, where you're told an indictment's going to happen. The next one is a preliminary hearing. Okay, that's what normally we deal with if we go through some criminal case because ours isn't murder related, put it that way. Or it's a grand jury processing. So they're literally choosing between a preliminary hearing or a grand jury. The best word is proceeding. I wrote down these notes so because I needed to learn and understand, so I studied some of it. So it's a grand jury proceeding or it's a preliminary hearing. Now, here's the clear difference. A preliminary hearing is when prosecution makes their allegations of probable cause in some way, shape, or fashion. Whatever they're trying to deem probable cause, they make their argument. Now, in a preliminary hearing, you don't hear a defense. Defense is not stepping up, speaking against them. It's nothing. They're just talking and they're just talking. That's all. In the grand jury proceeding, it's a little different because it's not just probable cause. It's also dealing with bill of information. That's where you guys are confused. The difficulty in the case going forward is the prosecution is trying to put together a bill of information. That's what they're having trouble. So they're trying to get DNA evidence. They're trying to do different things to pull in what they need to bring in probable cause. Because remember, I told you they did not check their hands. They didn't do anything we normally know to happen with gun-related cases. That's the difference. So they're having issues coming up saying, listen, these guys fired the gun and killed him. And I don't know why. And I'll go into more detail on the bill of information. But that's where they're stuck at. That's why it's confusing, because you see they're in a grand jury proceeding, but they're not closing that out. So at this point, a grand jury proceeding, yes, defense is putting together evidence, but prosecution's the only one who's delivering it. So they're the only ones that's going to deliver the bill of information to go along with their probable cause for how they got the evidence and for how they're trying to put these specific people on the stand for an indictment. So that's where they're having kind of trouble. And if that doesn't go right, the next step is where we'll see the lawyers of these men take hold and basically earn their name in the game of law. Okay. And that's the pretrial motion. This pretrial motion is where you file for suppression of evidence or some type of ideology to go against whatever probable cause was delivered in the grand jury proceedings. That's the key thing. And here's what has to happen. Here's why it's taking so long. You have to understand that prosecution has to build a very strong foundation for this evidence to stand in order for when pretrial motions comes, they can rebuttal real fast and say, nope, we got this, and this is why we're doing this to them. So you have to think through that part. That's where they're kind of stuck up, because they can't just slap something together. That's why they're asking for solid DNA evidence, because DNA does not lie. You got to understand that. Now, the choice whether they get it or not, I don't know. But yes, that is why they're asking for that. And they knew they should have collected it from the beginning. That's a key factor. If they collected it from the beginning, they wouldn't be having so much trouble now. But that's what's going on. And that's why I've said what I said as far as them trying to collect it now. I don't know if they could legally do that. But if they do, it will give the foundation they need to go ahead, deliver their cases on each person, and allow for a pretrial motion to go forward. Now, after that becomes the trial. The trial is where they decide guilty or not. And that's what we're used to. We're used to seeing a trial. So we're used to the fifth stage of the trial, where we just see people start getting indicted like, oh, he's guilty for this, guilty for that. That's what you guys are kind of confused isn't happening, but still pre-trial motions has to happen before that, because their lawyers get a chance to rebuttal with information to say, look, he didn't do this, he didn't do that, I want this suppressed. And then they go forward to the trial. And that's where you hear the not guilty or the guilty. Then after that is the sentencing. That's where you hear the punishment, which is the number of years or the minimum amount of years a person's going to get. So basically that's called the federal mandatory minimum. In this, you're going to hear basically, and what people don't understand is Florida has the death penalty. So for dealing what they did, depending on how much evidence is accepted at the pretrial motion, one of them could get the death penalty. That is why the lawyers fighting in a certain way they are, to make sure that that does not happen. Now, the next step is the sentencing. As I said, after that, after they get their punishment, then comes the appeal. That's when the lawyer comes back and says, look, you don't have this and this on that. You guys ruled this, this, and this. And if something was missed, that is their chance to get it back. But after the appeal is denied, that is when literally the punishment begins. So those are the 7 steps that are taken in the trial. Again, it's stuck at the bill of information. That's what number 3, that's where they're at, because these guys, instead of a preliminary hearing and then moving to the pretrial motions, because it's a murder and the death penalty is on the table for any type of murder, they literally have to have a strong bill of information in order to deliver that as even an option for someone, being the level of case and the rules and state laws that are in Florida. So don't be confused. Just understand it's at a standstill within the process. See, the process is never gypped. It's just, if it is, let's say a step is brought in faster than normal, that pretrial motion is where it's corrected. That's where all of the action is going to happen, where you're going to see the men defending these suspects step up and say, look, nah, it was this way. Or someone else comes back and say, nah, check this out. So there are 7 steps in it. We're at step number 3, and that's where we're stuck at. So we're going to see a lot of things go down with prosecution right now, because they're working with investigators to have not only probable cause, but evidence solid so that charges could come against them. That is why I say we do not know if they are actually guilty. You're innocent until proven guilty. That's like down in the 6th to 7th step. And then, you know what I mean? They're so early in the game. These guys are just trying to put together a picture. So see it this way. I pick these men up. I'm accusing them and stuff. Yes, they get defense, and these guys have solid defense, and they're standing on it. But the action and basically the foundation that builds around them being able to fight for innocence and everything is going to come in a pretrial motion, where they're fighting against what's put against them in the proceedings. The proceedings is up to prosecution to show and bear the truths that go against to make a guilty verdict. That's what they're trying to do. That's why I said they're railroading them during interrogations and bringing up random evidence, no matter how speculative it may be. But they're looking for their lawyers to rebuttal it in some way. If their lawyers do not rebuttal it successfully, they go down for this instance. And although it seems confusing, the only confusing part is the type of evidence they're bringing. And it's to see if it's admissible during the pretrial motions. See, pretrial motions are an argument of what's admissible in court versus the other ones that we're examining that's literally looking previously to say, look, here's what we have on the table. Then after pretrial motions is when they're saying, here's what's going to happen because of what we have. So the most critical part is yet to come. We haven't even seen any details or evidence that is a direct link or a heavy weight to hold down these men and link them to this situation. That is why you see lawyers putting out in public that these suspects, oh, they want this, they want that. That is literally a marketing tactic before the pretrial motion in order to, let's say, shake the investigators like, oh no, these guys are looking to throw the case out. So it's going to be done in that way in order to put that doubt in the public mind so that support is stronger for the suspects rather than the investigation of this superstar's death and saying that these men did it. And from our evidence that we've been examining, we don't even have clear-cut evidence that these 4 men worked alone. We also smell a 5th person, and that's the key part of it. Like, if you think there's a 5th person and someone else was giving orders, there usually is evidence to back that. But we won't know that until they pick someone else up and run them through the system. See, that's the thing. They have to run you from the beginning to the middle part to link you to it. And even if they picked up a mastermind, I don't think they're that confident they're going to have the evidence in order to put out a pretrial motion for the defense to try and fight against prosecution. See, prosecution has to think about what pretrial motions will come up and how would I divert this evidence in order to place them solidly to something. That's why I told you don't look at a picture and say they're guilty, rather than look at the huge motion of how prosecutors are moving, defenses are moving, what's being said, what actually happened, what's released, and all of this spells out the picture that they can use to place these men's face to the case without a doubt. And those are the steps that's going to happen. Again, we're at step number 3, where a grand jury proceeding has occurred instead of a preliminary hearing. And that is literally going to determine what prosecution's laying on the table. So they have to do it right. If they do this wrong, then the pretrial motion is going to get everyone off. That's why I said, did they collect information wrong that's going to allow these men to walk free? You got to understand, that's why it's confusing. That's what it's about. But that's how it goes. I'll have more information on that. You know how I rock. All right, so